Alrighty, this We the People News. One more time at it. Not attorney, not giving legal advice. Okay? It's educational only. Okay? Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Use the Second Amendment and arm yourself with knowledge. Okay? Self-defend yourself. Alright, again, I'm going to kind of keep this short and sweet. Remember, anything I say or do is just my opinion. Do not take it as legal advice. That's a big no, 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 no. Okay? I signed a contract somehow or another saying I will not give legal advice. Alright, so this is a legal beagle. And some of you guys know about Eddie Craig and all this and how does it work and even though he created documents and all that. Here in Texas, realize our judges is the #1 corrupt in the United States. Not number 2, not number 5, not number 10. It is actually the worst police state in the United States. Okay? And I dare challenge California may be second. New York may be third. But definitely Texas is #1. So, when people go out there and say Democrat or Republican, Texas is Republican, and they got the worst police state. Okay? California's Democrat, they got a bad police state. Okay? New York's Democrat, bad police state. Alright, so it's not a Democrat or Republican issue. It's a corruption issue on both parties. Alright? Let's hear what he has to say, because towards the end of this part of the video I'm going to make, he's going to be talking about the suit on appeal judges.
Okay? Until you learn how to read them. Once you learn how to read them and how to connect them together, see, there's this little rule in law called in para materia. Okay? That means things of like kind or same subject or same class. Okay? So when a statute deals with something on the same subject as another statute that deals with that subject, those statutes have to be read in para materia together as if they're one. Okay? And there may be more than 2 statutes. There may be 100 different statutes that deal with that subject. And all of them will have some bearing on what that subject must be interpreted as, how it must be applied, and how it must be understood to operate. Okay? Once you have all those collected and you understand that bigger picture that focuses down on this and all the angles it's got to come from, then you have more ways to attack their interpretation and application of that law. There's not one statute in any state that will give you what you need to specifically say that law does not apply to me. It is this myriad of statutes related to that subject that when you read them as a whole, make it very, very clear this cannot possibly be talking about you. Because all these things put together draw a completely different picture than the one you're trying to force me to look at.
Exactly. So for those following along, I haven't heard the para material together, but judum generis or whatever. But there are all rules all rules of statutory construction. If anyone is interested in looking that up and learning how to read the law, we have a lot of those posted.
Yeah, a justum generis is usually used when trying to interpret the meaning of words like includes or including. Gotcha. I've got an article about that on my legal blog, which is taooflaw.com with hyphens between the tau and the of law. But taooflaw.com, I've got 2 articles on there about includes and including. And I go into a very plain explanation of how any statute that uses those terms has to be read to operate properly.
Right.
And that's where you'll find the most discussion about the rule of a justum generis.
Right.
And that is things of like kind. Not the same subject, but things of like kind. And so when includes or including is followed by a list of things, then there has to be some common denominator relationship that exists between those things before the use of includes or including is valid.
Right. So you can't have a bunny, an airplane, and a frog.
It depends. Is the word stuffed in there? Or is the word toy in there?
Oh, well, Well, no, but my point is, if you have a list of animals and you add an airplane to it, that's just not going to work.
Right.
Yeah.
If the presumption is these are supposed to be live animals, you are correct.
Yeah.
But if the previous up to and including any toy, including rabbits, airplanes, dogs, blah blah blah, now you've got a whole different meaning.
Yeah, we have to apply some common sense.
Yes, but now you know for sure the class of things are listed to toys.
Right.
Okay. So using includes and including in statutes, you really, really have to understand how those terms operate, or you will never, ever have a proper understanding and interpretation of the statute you're reading.
Very, very tricky and deceitful these laws are.
And I'll pause right there, right? Of like kind, okay? And argument's sake, okay? Men and women, all right? They're one like kind. People that can be gathered as a group of one like kind, okay? Now, when you go into a man, one of the people, that would create one statue of one like kind, okay? But in statutes, when it's like a person, the legal person, right? Well, they never put in the statute the legal person, and then in that same statute, they don't put man or one of the people, okay? So the person, the legal person, 99.9% of the time is a one like kind separate from one of the people and a man and woman, okay? And it has to be that way because under their definition, it's a fiction, okay, of that person. Now, there is other persons in there. It can kind of go into a little bit more detail. But that being said, most generally, overall, that's what the person is. It's separate from one of the people, and it's separate from men and women because the statute never put in there saying the person, the meaning of person, definition of person, a man and a woman, and one of the people. If they don't have that in the statutes, then it cannot be in that category of one like kind. It's separate.
So, if you, we're an hour in. If you have a little more time, I'd like to discuss the differences in the traffic versus the criminal. If you want, cases.
Sure.
If you would be so kind as to go into a brief example of the criminal code and.
Well, here in Texas, traffic is criminal.
Well,
all traffic offenses in Texas are criminal.
Right.
They're
but they're handled a little bit differently, right?
Yeah, they have two separate sets of rules. They have the regular Code of Criminal Procedure, and then they have a subset of rules within the Criminal Procedure, Chapter 45 and soon to be Chapter 45A, that deals with specific Class C fine-only offenses, not just traffic, but any Class C fine-only case in a justice or municipal court. The one thing about those chapters, though, for that specific subset is that it tells you very clearly that if that subset of rules does not deal with something that the other set of rules does, then the other set of rules, the bigger set of rules, is actually controlling in that particular aspect. That's something else they don't do here. If it's not in this subset of rules, they don't care. They're going to do it how they want, regardless of what the bigger set of rules says they're required to do. And that's part of the problem. Our highest criminal court in the state of Texas has knowingly and willfully violated law to create a set of rules of procedure that violate that law. So what they do in practice is in direct violation of the rules governing the practice they're required to follow. And that's what Randy's lawsuit was all about. The problem is, it was Randy's lawsuit. So what I'm doing now is I am rewriting his lawsuit to actually be pertinent. And we're going to use it to go after all these judges that are ignoring the law and ruling against people without providing due process. And we're going to do the exact same thing Randy was talking about in showing here are all the things the Code of Criminal Procedure requires Here's why all the case laws saying they don't have to do this is bad. And here is why every case involving this is invalid and needs to be reheard, which is trillions of freaking dollars if that ever comes to light.
Right. No, of course. But I mean, as we've seen, Merlin for sure has taken several tax cases through to the appellate courts, and several appellate courts rule in direct contradiction to what the SCOTUS says, because they're protecting the money.
Yeah,
the status quo.
Status quo.
I mean, do you want to be the judge that says there's no more property taxes in America and what the ramifications that is? I think that's a pretty heavy burden.
Well, the thing is, they misunderstand the burden. Would you rather be the judge that says we've been doing it wrong, or would you rather be the judge that says piss on the Supreme Court and wind up getting your bar card yanked so you can never practice law?
Well, we haven't seen much of that happen.
No, we haven't, and we need to.
Yeah, agreed.
But the thing is these judges think that they're impervious, but they're not. Remember that the federal Constitution says these judges hold their office only so long as they are in good behavior. When their behavior violates existing law or the Constitution, they're removable. They can be impeached and they can be removed from office.
Yeah. With let's see, the that Congress up there. If we're talking about federal judges, of course, can you imagine an impeachment vote going through and then the Senate holding a trial?
No, not with the morons we have.
No, that's just not possible.
But I for one, would think, that at this point, burning down all of Washington, D.C. while it's fully occupied would not be a bad thing for this country.
Well, there's an old...
So even with that behalf, right, I've talked about on previous videos, this is where we, the people, actually start using our political powers of one of the people, and to use the First Amendment and in writing petition our redress and do our remonstrance and start getting, like your particular states, wherever you are. Texas, the impeachment constitution is Article 1, Section 15. Okay? And that we had to go through the process and instruct our legislatures to start impeaching these judges. Now, let's just say a lower judge, for whatever reason, decides ruling against you, but you actually had legal and lawful standing for jurisdiction issue, right? When you challenge jurisdiction, they must tell you. Well, if they keep proceeding forward, I think that we, the people, excuse me, as soon as that happens, you can do more paperwork and go to the appeals court or whatever. But at the exact same time, you go directly to the legislature with your petition in writing and start the process of impeaching that judge. Now, the legislature probably not going to do a whole lot, but what they're going to do is tell the judge over there where your judge at, right? This guy is, or a woman or a man, all right, filed a paperwork to start the process impeaching you. What have you done, right? Now, whatever judge that would be, is start to be a little bit nervous, okay? And the more of us stands up and really starts putting a squeeze on these people, even though they may not do nothing, they'll wake up and realize that people is getting sick and tired of these things, and they're not using their bar friends. Okay? We're starting to be wiser and more educated on some of these things, and we're going to start filing criminal complaints on them and take them to the magistrate to issue warrants for their arrest and all that kind of stuff. So, we've been doing the exact same thing. We've been calling attorneys. Where has it gotten you? Okay? When you did your own represent yourself as, let's just say that average people, okay? Represent yourself. But you found in the wrong, but you're innocent and all that. But you keep doing it over and over and over. Well, that's the definition of insanity, right? So we got to step out of our comfort zones and keep poking them, waking them up. Every time that judge steps on a thorn, he wakes up. He may go, ow, and it may sting, but he woke up.
Saying about when Edward Edwards was governor here. I think he was governor 4 or 5 times. They said they sold the voting machines to Mexico when he was elected governor of Mexico. But there's an old saying of all the lawyers and Edward Edwards. Any other things that you see that are egregious, of course. But they probably do go to grand juries for these things, right, or no?
Yes, most of them, unless, like I say, unless they don't involve incarceration in a state penitentiary, they do.
Okay.
But again, the process is supposed to be the same regardless of the level of the offense. They're still required to have the examining trial. They're still required to have the grand jury indictment. They're required to have all of those things. They just don't do them because they're inconvenient to them instead of to us. But rather than protect our rights, like I say, they're after their conviction rates and their money so they can seek higher office and more of it. That's what it's all about. But I don't know. The process for this stuff. Have you ever read our Texas Constitution?
I've read some of it only because I was referencing some of Randy's lawsuit when I read it. He is a little bit long-winded.
Yes, and a little bit off track. he tends to wander a bit.
He does wander a little bit, but he does know his stuff.
Yes. Now, he and I had a discussion the other day about how, procedurally speaking, his lawsuit shows that he's guilty of the same problems that the courts themselves are guilty of. He was laying out the process as he understood it. But the way he understood it, I would taught this in my class before last. And we were going through it, and I was saying, okay, here's Randy's lawsuit. Here's what he says they're doing wrong. And then here's the actual statute. Well, when you read the actual statute, Randy is still laying out the process incorrectly, just like they are. He's laying it out a different way of incorrectly, but it's still incorrect. For instance, in his lawsuit, he says that the prosecuting attorney or the magistrate is required to send a complaint to the judge of the examining court, and the judge of the examining court is then required to send it to the court having jurisdiction to try the case. Well, that's not what it says. It does say that in one part, which is the general section, but in the detail section, it specifically says that he must send that package to a court clerk of either a district court or a county court. It's not sent to the court, it's sent to the court clerk. And the court clerk is then required to forward it to a grand jury. Gotcha. So it's not the.
Let's see, I missed that as well. I had to think about that a little bit too, because I missed that altogether on the statute too. So I'm with Randy Kelton. I got a little lost on that one. And I'm going to have to reevaluate that. So, the clerk is one that sends it to the grand jury. If she does not send it to the grand jury, then you file a criminal complaint against the clerk of our bar grievance against that clerk.
Magistrate that gets his hands on it, which is what Randy was saying was supposed to happen. It's the court clerks who get their hands on it and what their duty under the law is to do with it. But in every case, whether it's a county or district court, they're required to send it to the grand jury. The grand jury must then look into it, true bill it, or no bill it. Only then can they get the trial.
This goes to show you, kids, that no matter how long you've been doing this, there's always something to learn.
Yeah.
For sure.
Sit and think about that, right? Before you even get to trial, there must be a grand jury. All right. This week, People News. Bye, y'all.